what you probably want to hear was that Tatsunoko licensed some rights to Big West and then licensed those same rights to another company, Harmony Gold. And then there was a lawsuit in the 90s, and that was resolved, and Harmony Gold apparently owns everything in the US except for those 41 original drawings. And then Harmony Gold has been exploiting Robotech for the past, 20 years. More than 20 years, 30 years. But Harmony Gold then continued for 20 years to exploit the works, and now Tatsunoko somehow got it through their head that they were owed some additional money or something, so they initiated some kind of action or audit or something, and then Harmony Gold said, screw this, and started an arbitration proceeding. The arbitrator has reviewed and or considered the pleadings, witness testimony, exhibit books, documentary evidence, post-hearing briefs, and the numerous arguments presented by the parties, their legal theories, and reliance on statutory and case law, including those not specifically addressed above, all of which have been carefully considered in reaching a decision, and now makes the following determinations. Award. Declaratory and other relief granted in favor of claimant Harmony Gold. To the date hereof, claimant has not materially breached any agreements with respondent related to the programs, nor infringed any of respondent's rights therein, including but not limited to infringements on respondent's copyrights or fraudulently registering Macross trademarks. So Harmony Gold's not the bad guy there. The original agreement and operative agreements grant claimant the right to make derivative works of the programs and Robotech, including live-action motion picture adaptations, and claimant has not produced any unlicensed works. The 2003 agreement is valid and binding on respondent, and claimant has been granted therein all of respondent's copyrights in Macross, except for the visual depiction of the original 41 animated graphic characters from the underlying program pursuant thereto. The operative agreements grant claimant the express right to sublicense its rights as it chooses, and claimant has neither breached said agreements nor infringed on respondent's rights by entering into such sublicenses. The operative agreements grant claimant the express right to exploit the programs and any derivative works in all media, including digital, and claimant has not breached said agreement. The operative agreements grant claimant the right to exploit the programs and any derivative works through sublicensing of music and clips. Claimant owes no royalties for home video exploitation pursuant to the 1991 license agreement. Claimant has had the right to offset royalties otherwise owed to respondent in the sum of $541,362, incurred by claimant in connection with the Big West litigation until recouped. To the date of the last royalty statement or audited date, claimant has fully accounted for all royalties owed to respondent except for the amount of $42,543, which claimant is to account for and pay to respondent forthwith, subject to any continuing proper offsets. Respondent's audit and other claims are identified in the body hereof, and respondent's request for relief are time-barred as they arise out of claims more than 4 years old. As of this date, respondent is not entitled to terminate the operative agreements or otherwise curtail claimant's rights thereunder. Harmony Gold claimant owns in perpetuity the title Robotech and the produced Robotech programs with exploitation thereof, subject to respondent's rights on termination of the operative agreements. So, to summarize the first part there, Harmony Gold owns all the rights that we've been talking about. They basically won that part of the dispute. And they have the right to continue to produce derivative works and to continue to exploit the existing works until 2021. May? Whatever that date was. Which I suddenly can't find. March 14th, 2021. Relief granted in favor of respondent Tatsunoko Productions. Harmony Gold's right to use the programs expires on March 14th, 2021, along with any extant sublicenses, as all rights to the programs revert back to respondent at that time. Upon expiration of the term of the operative agreements, the claimant no longer has any right to use or exploit derivative works produced during the term, which contain portions of the programs, as rights to the programs revert back to the respondent at that time. So everything goes back to Tatsunoko on March 14th, 2021, which is a little less than 4 years away. Claimant has no permanent, exclusive, and irrevocable copyright and trademark rights in the programs, as same shall belong to respondent on expiration of the term in 2021. Upon expiration of the term, respondent shall have the right and option to disaffirm, cancel any existing licenses, assignments, or other agreements extending beyond the term as may have been entered into by claimant with others granting any rights to the programs. Claimant is to pay to respondent the sum of $42,553,000 as the result of the audit, subject to any remaining proper offset rights due to the Big West legal fee expenditure, which we don't have a number on that. So who knows if that money is actually due or they just take that off of a spreadsheet somewhere. The award of all costs of the arbitration is to be determined in the sole discretion of the arbitrator and in accordance with paragraph 14 of the rules, as the operative agreements do not provide any guidance. At the closing hearing on May 19, 2017, the arbitrator advised the parties in writing that legal fees are to be reasonable and directly related to arbitration, but need not be the same for each firm, as, for example, pay scales, attorneys, etc. may be different. The arbitrator determined that it is appropriate to consider only costs relating directly to this arbitration. Thus, the arbitrator finds that claimant, as the predominantly prevailing party, is entitled to recover from respondent such costs as adjusted by the arbitrator in the total amount of $848,000, which consists of claimant Harmony Gold USA's legal fees allowed by the arbitrator as being reasonable, in the amount of $711,000, and claimant's costs of $137,000, which include its share of both the IFTA filing fees of $1,100 and your arbitrator's fees of $25,612. This award is in full resolution and settlement of all claims and counterclaims submitted to this arbitration. All claims and counterclaims not expressly granted herein are hereby denied. This award may be executed in any number of counterparts, etc. Signed, Jack Friedman, sole arbitrator. So what do you think of that? Holy mackerel. That was very complicated. That was very, very complicated. It was so complicated, we're going to go put dog video back on. I don't even know where the dogs are, so I'm going to go find them in the video. There they are. Okay. So, yeah, that was really freaking complicated. So, Big West had some rights. Tatsunoko sold off rights that they didn't have. No, don't close OBS. Thank you very much. Tatsunoko sold off rights they didn't have. They got caught up in that. They corrected that in 2003. Then it sounds like Tatsunoko didn't do anything for about 10 years, and then someone recently was like, hey, we should sue Harmony Gold for all this stuff they're doing. And it sounds like Tatsunoko didn't fully understand or wasn't fully clear about their licensing agreement with Harmony Gold. The other half of that is, if Tatsunoko, if their relationship with Harmony Gold has now soured, they can revoke everything on March 14th, 2021. So, yeah. So that's that. What do you think about that? Battletech and MechWarrior, I think Battletech and MechWarrior are safe, but this case was not about that. I was hoping that this would answer questions about the Battletech and MechWarrior cases with Harebrained Schemes and Piranha Games, and this did not answer any of those questions. Except one, maybe like why now? This might be the answer, why now? Because Tatsunoko started some kind of action with Harmony Gold, and Harmony Gold probably started the action with Harebrained Schemes as a result of all of this. So maybe the Harebrained Schemes and Piranha Games litigation would already have been going on anyway, but maybe it also got started because Tatsunoko was pressuring Harmony Gold about this stuff. A couple people are asking for a recap. So Tatsunoko, I believe it was Tatsunoko, was the original creator of basically the original works that led to Robotech, which were Macross and Mospita and Southern Cross. And then Tatsunoko licensed those rights to various entities, and this whole reading for the past hour was trying to understand what in the world were all those relationships. So finding out those relationships between all these different parties probably isn't the fulfilling part. What you probably want to hear was that Tatsunoko licensed some rights to Big West and then licensed those same rights to another company, Harmony Gold. And then there was a lawsuit in the 90s, and that was resolved, and Harmony Gold apparently owns everything in the US except for those 41 original drawings. And then Harmony Gold has been exploiting Robotech for the past, 20 years. More than 20 years, 30 years. But Harmony Gold then continued for 20 years to exploit the works, and now Tatsunoko somehow got it through their head that they were owed some additional money or something, so they initiated some kind of action or audit or something, and then Harmony Gold said, screw this, and started an arbitration proceeding. And then I'm speculating after that, I think it was filed against Harebrained Schemes and Piranha Games. So it sounds to me almost like Harmony Gold is not the bad guy here. I mean, I know a lot of people were really up in arms about Harmony Gold suing BattleTech, but it sounds an awful lot like Harmony Gold was in some kind of legal trouble with Tatsunoko, and it wasn't their fault. Separately, Harmony Gold is also suing BattleTech and MechWarrior Online, Piranha Games, and Harebrained Schemes. So that is, I'm just going to have to treat that as separate. I don't know what infringement there was there. I did not do and could not immediately see a legal analysis as to how you figure out which mechs look like other mechs. I mean, it's like saying that a camera, a DSLR digital single lens reflex camera, shouldn't look like it has a grip on one side and a lens on the front. I mean, they all gotta look like that. That's what a digital single lens reflex camera is. So a mech, a bipedal, anthropomorphic mech has got to look a little bit like a person. So at what point does it become copyrightable? When I add some little drawings on the thing, or when what? Like, how much detail do I have to add before that becomes copyrightable? So the standard is access and substantial similarity. They obviously had access, so we just have to go through the substantial similarity analysis. So how is plaintiff going to prove BattleTech 3D objects are the same as 2D objects, even if they look similar? Honestly, that usually has to go to either a judge or a jury, and they have to be given stuff that we haven't even seen yet. They have to be given evidence and testimony to look through, understand, and then they will weigh those understandings whether they fit a definition of substantial similarity or not. I don't have any more guidance for you. You're going to be looking at two things and making a judgment call. And if the jury comes up that they feel that the material is substantially similar, then Harmony Gold wins. That's really it. I mean, there's more to it than that, but that's the simplified version. Flash frames. So in regards to mech designs from Macross, does Harmony Gold have those, or do those fall into Studio News rights, given it seems as though the 42 characters from the original Macross may cover those designs? So it seems like Harmony Gold owns absolutely everything from Macross except those 41 original designs that belong to Big West. What that means and how that plays out, I don't know enough about that to speculate. So thank you all for joining me. I do have a Twitch gaming channel. We play a lot of PUBG on there. I'm going to go throw the ball in the backyard for the dogs for a little while, and then I'll probably be playing a little bit of PUBG. So anyway, I love you all. I want to thank all of my supporters. Let me pull up all of their names. I know that New Sensei is eagerly awaiting the video that he has paid for. New Sensei has sponsored... Wow, there's just so much going on. New Sensei has sponsored a video, The Basics of Copyright for YouTube Creators. I'm still working on that, but it should be out this week. So thank you very much to New Sensei for all of that sponsorship. Thank you for the $50 a month supporters: Joshua Meinziger, Baxorn, John Cripps, Nate Beck, John Steele, Weston Loney, and Lydia Collinson. Those are my $50 supporters for August. Very much appreciated. And my $5 plus supporters are scrolling on the LED panel behind me and should be in the description below at some point if they're not already. So thank you for joining me. I'm Leonard French, your favorite copyright attorney. I'll see you on my Discord server, which should also be somewhere in the description below, or on Twitter. So thank you, everyone. I'm Leonard French, your favorite copyright attorney, and I will see you in my next video. Have a great Sunday. Have a great week. Love you all.